consider the damage out of state environmental protection.
Oh, gotcha.
Happening out at 3. It's happening at 3. Same old. Here, Shelly's going to the desk now. Is she on there yet? That's good. How's she liking it? Right. Yeah, she's got to be liking it. Yeah, everybody left there. Chris left there. Oh, yeah. Like every time I talk to somebody else left there. Yeah. How long are you gonna be there? Till you retire? You know, but I think I'll be here until I retire, but I'm already, I'm almost, I'm here. Yeah. Oh God, I hope I'm not 70 when I retire. Well, it could happen. I could see it happen. Yeah, I think so.
Exact opposite for us.
Yeah.
We're used to.
I would have better for a month than it was.
We're used to it. All rise.
Thank you. Please be seated. Mr. Boisel?
Thank you, Your Honor. Your Honor, we are here in case number 22CR1041, State of Ohio versus Willoughby Koubeck. We are set today for a sentencing. Mr. Koubeck is present today in court, represented by Mr. Patterson. Your Honor, we were last together on the 4th of January. We were defended under plea of guilty to the attempted assault on a police officer, felony of the 5th degree. Your Honor, in addition to myself being present, we have members of the Willoughby Police Department, including the victim in this case, Stacee Wright, as well as Police Chief Jim Schultz. Your Honor, we are prepared to proceed and have had the opportunity to review the pre-sentence report in this case.
Thank you. Mr. Patterson?
Yes, Your Honor, we had an opportunity to review it now, and this is the first opportunity I've had to give to Mr. Koubeck to show him, and he indicates that the statement that was made, it's in the report he did not make, and that was the statement that he stated if he was 20 years younger, she'd be dead. And that was a terrible statement, and he did not make that. He did not make it to the person doing the interview at the probation department, so that should be taken out. He flat out denies that ever saying that. He never told me he felt like that. He never told me that he felt anything other than sadness because this all happened.
Okay, you ready to go forward with sentencing?
You want to do that? We'd like to get that statement straightened out, though, Your Honor. That's not a true statement. He didn't. It's a terrible statement. He's not that kind of a person. He wouldn't make a statement like that. I would like to put that off until we can get that rectified and the report and see what happened, why the lady took it down that way. That's all. I don't know any other way of doing it. It was set for scheduling for sentencing today, and I know it's not a bad. It's a bad statement. I truly believe that Mr. Koubeck did not make that statement. I mean, if the lady is here and would say that on the witness stand that he said that, then we can't do anything about that.
Your Honor, if I may respond, even if we strike that statement, the statement would still include the statement that he says to the probation officer, given the opportunity, he would have killed that fucking bitch. So I have a hard time believing that the last statement in there regarding if he was 20 years younger, she would be dead, was false, when the other statement, which was made 8 or 9 lines prior to that, was also part of that statement. I think it fits the context exactly with that. I spoke with the probation officer myself, and it's my belief that is exactly what was said during that interview.
All right, well, Mr. Patterson, for purposes of the record, I guess, I agree with the prosecution in terms of the context, that it's still within the context of the statement. I would tend to believe it, but I mean, I could, even if I strike that statement, would you still be comfortable then going forward with sentencing?
Yes, he would be if you take that statement out.
Okay. But, well, to move things along, I'll take out that one statement then from the pre-sentence report.
All right, thank you, Your Honor.
All right, so please continue then. What
Okay,
would you like to say on behalf of your client?
On behalf of my client, I would just like to say this. I have bad knees and legs, and I know how it is to tell somebody to go sit down, and that's what he was told to do. If he would have just explained to her, look, I got bad knees from working on cars, and my knees and legs are bad, I cannot just sit down. But it got way out of proportion. And all I can say is that by getting out of proportion, it went south, and that's not the right way to handle it. We have to respect the policeman. I respect the policeman. We all have to do that. When somebody says to do something, you should do it. All you have to do is explain, I can't get down on my knees, and like you want, I'll stand up, and that's what should have happened. I think she was a little over-aggressive. If you look at the video, and even the experts that we have look at the video, say she's a little over-aggressive. I don't think it's in her training to do it that aggressively and proceed forward with like he did. But both situations got out of hand. My client got out of hand, she got out of hand, and we put that together, and we had a blow up. And that's what happened here. We apologize for it today. We're sincerely sorry to the police officer what happened, and it's not the way to carry on any kind of business, any kind of stop. But it didn't work out the way it was supposed to, and he was upset that day. He had gone to his mother's house to work on it and had got some problems there, and things that he carried over from one thing to another. He's not had any prior record, he's not had done anything wrong. I've known him for 50 years, and he's 64 years of age now, and he's done everything he's supposed to in life, but this happened up. He has a mother that's 93 years of age he has to take care of. We hope that you wouldn't put him in jail at this time on the basis that he takes care of her. He's the only one that takes care of her. He has a sister, and she also helps out, but the mother needs help all the time, every day. She, too, also has trouble getting around with her knees and legs. So we would ask that you, as we had talked to the as we had talked to the prosecutor, we had indicated we hoped and we asked for, and we thought it was agreed on that he would get probation and he would not have to go to jail. And as a result of that, we're still asking you that to enforce the agreement we have with the prosecutor to have community control at this time. Thank you very much, Your Honor.
All right, thank you. Mr. Koubeck?
Do you want to say
All right, this is an opportunity for you to address the court before you are sentenced. Okay, what would you like me to know before you were sentenced today?
That what's in this statement isn't actually accurate and correct, and that I was hit first, not me hitting her. I was standing there with my arms at my side. I got hit first on the right-hand side, which knocked my glasses and my hat off and my sunglasses. I was standing next to an 8-inch curb. I couldn't see, so I immediately put my arms up to block any attack, and she kept on attacking me. I could not get her attacking me until I backed off, and then I ran into the ground like Rodney King.
Okay, anything else you would like me to know before you were sentenced today?
That I wish the altercation never occurred. You know, I apologize for my self-defense. Things could have gone better. You know, I wish it never happened. Basically, wish the whole altercation never happened. I don't know if I was supposed to sit in the car. If I was sat in the car, I would have gotten dragged out. I did everything to comply. I couldn't get any communication into this officer of what the situation was, what was going on. Had a lot going on at that time that I was trying to handle mentally and physically, and then this altercation happened, and you know, for the last year and a half, it's been hanging over my head, and I'd like to get it over with.
Okay, thank you.
Know, I'm sorry that it happened, you know, and you know, but I've always supported this police. I just would like to get it over and done with. Appreciate your time. Thank you very much, Your Honor.
All right, thank you. Mr. Boyes, on behalf of the state.
Thank you. Your Honor, the state did have the opportunity to review that pre-sentence report in this case. Aside from the statement that has been stricken, it's very clear how he felt about that day. He feels he was not at fault. He mitigated every step of the way. He's tried to deflect any wrongdoing on his own behalf. He has essentially placed the blame on the officer who was involved just doing her job, completing a traffic stop on that day. Would have killed that fucking bitch. That's his words. Those words are not stricken. Those were his words given to the probation officer during the pre-sentence investigation and report. Your Honor, I think it's appropriate at this time, since it's not been made a part of the record, to show the video. The defendant argues and alleges that this video that was provided was trimmed in any way, shape, or form. Well, it's not trimmed. I have the full video, and I'd like at this time to play so the court has, for the totality of the circumstances surrounding this incident, can see exactly what transpired on that day. We'll be able to watch the interaction. We'll be able to see that Mr. Koubeck exits his vehicle without being asked to exit his vehicle, that Mr. Koubeck fails to respond to any of the commands by Officer Wright, that Mr. Koubeck is the first person to become aggressive, and that Mr. Koubeck ultimately ends up taking the officer down to the ground. And the only reason, or one of the main reasons, the officer was able to get up from that is because several citizens from Willoughby and the area got out of their vehicles to come to her aid and to her rescue. So at this time, Judge, with your permission, I'll go ahead and play the video for you.
Go ahead.
And officer, this is the live dash cam video from Officer Stacee Wright on the date of the incident as she's traveling down Lost Nation Boulevard in the city of Willoughby, Lake County, Ohio.
Lost Nation in the airport with Tom and Ocean, Robert Edward Warren.
Hello. Monster Willoughby Police Department. Blue line stopping me to speed. 57 and 35. You're going 57 and 35, sir. You have driver's license with insurance. Why are you getting out of the car, sir? My driver's license. 12 radio to know to step out of the vehicle. Step over here now. Have a seat on your own. Have a seat.
I'm not sick.
I'm not sick! Back off! Back off!
I'm not sick, mother.
We're getting physical. Put your hands behind your back.
I'm
I will tase you, sir. Touch the vehicle. Put your hands on the fucking vehicle now! Radio stomach unit. Roll over on your stomach now. Fucking ground. Knock you off, man. Knock you off now. Get your arm behind you. Put your arm back. Hey, shut up. You don't do that to a woman. Do you understand me? You don't do that to a woman. Stand up. Walk back to my car.
under arrest for assault on a police officer. Have a seat.
That is the first 4 minutes and 52 seconds of the dash cam. Uncut, unedited, raw, directly what happened on that day. Never once was he asked to step out of the car. This image that he had in his head during this PSI that he completed, this image that he's presenting to the court today, isn't the reality of what took place. He wasn't asked to leave the car. He wasn't asked to sit down outside right away. All that took place because from the moment the stop began, he was properly informed of the reason for the stop and then chose to do things his way and then became violent and aggressive with this officer. Your Honor, Ms. Wright is present here today. And at this time, Your Honor, before I go further with what I have to say, I'd like to give Ms. Wright the opportunity to speak.
Okay. Ms. Wright, just so we have a clear record, make sure you state your name and loud enough so the microphones can pick up. In our
Yes, sir. Officer Stacee Wright. My last name is spelled W-R-I-G-H-T. I work for the city of Willoughby. On that day, September 10th, I was doing my job. I work day shift. It's midsummer. It's a residential area. This gentleman was going 57 in a marked 35-mile-per-hour zone. We do have accidents involving children, involving bicyclists. That's our primary reason for doing speed on that particular road. It is a long stretch, and it's 4 lanes, but people don't always pay attention. They walk out into the road. Anything can happen. That's why we do our job. That's what I was doing that day, was my job. I was enforcing the ORC, which is the Ohio Revised Code, as well as the city ordinance for speed. Mr. Koubeck failed to abide by that speed limit. I looked at his driving record, and it was going to be a, hey, we need to slow down. We do have accidents in this area. From what I recall, he didn't have a bad driving record, but he had been stopped before. He had previous stops, so he knew what to do when interacting with a law enforcement officer. The only thing I agree with him on in his statement is this has gone on, and I would like it to be over. This has been through the media. My family has had people contact us about this. My department has had people contact us about this. I've received threats because of this. If you are an adult and you make adult decisions, you should have those same consequences and take responsibility for yourself. That's all I have to say, sir.
Thank you.
Your Honor, as a result of this incident, Ms. Wright suffered jarred teeth. Her teeth were jarred loose as part of this. She had to deal with that. She had a laceration on her face. Mr. Patterson indicated that the state had relayed an offer that included community control. That is 100% accurate. Part of our offer is community control. Community control includes jail time. I would ask this court to give the maximum jail sentence possible on this case. I do not think there has been any remorse on behalf of the defendant. I think he has done nothing but mitigate and skew this to some version that he has created in his head that does not align with what took place on that day. I would also ask, in addition to that a mental health assessment be ordered. I would ask that anger management be done. I would ask that he has to continue to comply with all the terms of probation, and that it shouldn't be a short probationary period. This should be one that goes beyond a 2-year period, because clearly he's having difficulty complying with terms. So that's what the state is going to ask for here today. That's what the state feels is appropriate at this time. Thank you.
All right, thank you. Well, I considered the record, the oral statements made, pre-sentence report, the victim impact statement made today in court today. By conference in chambers with counsel, the statements of the defendant, defendant's counsel, and the prosecutor. I've also considered for the overall purposes of felony sentencing, pursuant to Revised Code 292911, which are to protect the public from future crime by this offender and others, to punish this offender, and to promote the effective rehabilitation of the offender using the minimum sanctions that the court determines to accomplish those purposes without imposing an unnecessary burden on state or local government resources. And I've considered the need for incapacitation, deterrence, rehabilitation, along with public burden on governmental resources. I've considered the recommendation of the parties made here today. I've reasonably calculated this sentence to achieve the overriding purposes of felony sentencing and be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on the victim, and be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I've considered all the relevant factors, including the seriousness factors set forth in Divisions B and C of Revised Code 29-29-12, and the recidivism factors set forth in Divisions D and E of Revised Code 29-29-12. With respect to the seriousness factors, I do not find that any of those factors in particular apply in this particular instance. However, looking into the recidivism factors, meaning factors that indicate whether this particular offender was likely to commit future crimes or not, the most significant one indicating that this offender would commit future crimes is the complete lack of remorse shown not only in a pre-sentence investigation report, but even in court today, indicating basically defendants saying that basically trying to shield himself from any blame in this whatsoever. Frankly, the statements made in the pre-sentence investigation are troubling and disturbing. Making factors indicating defenders less likely to commit future crimes that weigh in his favor are the fact that he has no prior juvenile adjudications, no prior criminal convictions of any note, he has 4 speeding tickets only, no other contact with law enforcement of any note whatsoever, and has led a law-abiding life for a significant number of years. So, fortunately in this case, the victim was not seriously hurt, and obviously I do think a term of incarceration will be appropriate in this case, as well as some significant treatment. So the court finds prison is not consistent with the purposes and principles of felony sentencing, and defendant is amenable to available community control sanctions. The court hereby imposes a period of community control for 3 years, subject to the general supervision and control of the Adult Probation Department under such terms and conditions as they find appropriate. Among these, you shall not leave the state of Ohio without the permission of the court or the Adult Probation Department. You shall abide by all laws, including but not limited to the laws related to firearms, deadly weapons, and dangerous ordinances. The court further imposes the following specific sanctions and conditions. You're to serve a term of 180 days in local incarceration with credit for 5 days served. Court orders a mental health evaluation, which will include anger management. You are to follow all aftercare recommendations. I have also considered your present and future ability to pay financial sanctions. In accordance with Revised Code 29-29-18, I'm going to impose a fine of $500, as well as paying probation fees and the cost of prosecution. If you violate the terms of your community control sanctions, a motion to terminate community control will be filed. If finding you violated the terms of your community control sanctions, I can impose more restrictive sanctions upon you, including sending you to prison for up to 12 months. You still have a prison sentence weighing above you if you violate the terms of your community control. If you do violate your community control and are sent to prison, you may have to be on post-release control for a period of up to 2 years, as determined by the Adult Parole Authority. If you are placed on post-release control and violate any of the conditions of your post-release control, the Adult Parole Authority may impose more restrictive post-release control sanctions or return you to prison for up to 9 months for each violation, up to a maximum of 50% of your stated prison term. Your violation of post-release control is a new felony offense. You may be prosecuted for that new offense, and the court which you're being prosecuted for that new felony may impose an additional consecutive prison sentence for the post-release control violation. The maximum prison term for the post-release control violation shall be the greater of 12 months, or the period of post-release control for the earlier felony minus any time you spent under post-release control for the earlier felony. As I indicated, defendant, in addition to the fines, ordered to pay costs of prosecution and probation fees. If you fail to pay the judgment of costs of prosecution or fail to make timely payments towards that judgment of costs of prosecution, under a payment schedule approved by the court, I may order you to perform community service until the judgment is paid or until I'm satisfied you're in compliance with the approved payment schedule. If I order you to perform community service or receive credit upon a judgment of costs of prosecution, the rate of $10 per hour of community service, and each hour performed will reduce the judgment of costs of prosecution by that amount. At this point, the balance in the indictment will be dismissed. Bond will be released. I do hope you get the anger management treatment you need. That seemed to be very apparent in that video, if you couldn't see that. Is there anything else from the state that we're leaving out here?
It's possible I missed it, Judge, but just no contact with the victim.
Yeah, of course, no contact with the victim. Anything else from the defense at this time?
No, Your Honor, we will not have any contact with the victim, actually.
Okay, anything else from probation?
Nothing further, Your Honor.
All right, thank you. Then we are adjourned.
All right.
Yes, yes, I'm sorry.
No.
You okay with this?